Right, it's another Tuesday right here, and it's time for us to talk about the Administration of Criminal Justice Law 2017. This is the Wheel of Justice, and the show was designed to make sure that every aspect of this law is broken down in a way we can all understand it. And my name is Ifeanyi Awa. Don't forget that Wheel of Justice comes your way every Tuesday from 3:30 p.m. and it is brought to you by the Abia State Administration of Criminal Justice Monitoring Committee and Prisoners Rehabilitation and Welfare Action Prawa, with the support of the Open Society Initiative for West Africa (OSIWA) and the Abia State Justice Reform Team. And on this week's edition of Wheel of Justice, we'll be talking about the prevention of offences and security for good behaviour under Section 50 to 56 of the Acjl 2017. This is the part one of it, and if you do remember, we just handled the two parts of the arrest of warrant, but today we're moving into the prevention of offences and security of good behaviour under the Section 50 to 56 of the Acjl. I have a guest here with me who would be dissecting this so that we can easily understand it. But before I introduce her, let's take a quick breather. Right, once again, let me remind you that this is Wheel of Justice, and the major aim is to help us better understand the Administration of Criminal Justice Law 2017. And just like I said earlier, it is brought to you by the Abia State Administration of Criminal Justice Monitoring Committee and Prisoners Rehabilitation and Welfare Action Prawa, with the support of the Open Society Initiative for West Africa (OSIWA) and the Abia State Justice Reform Team. My name is Ifeanyi Awa, and on this week's edition, I have with me His Worship Chinwe Bob Ogu, and she would be dissecting the prevention of offences and security for good behaviour under Sections 50 to 56 of the Acjl 2017. This is the first part. I want to welcome you to our studios. Welcome.
Thank you very much. Okay,
now, just like I told you earlier while we were speaking, basically, we do not have a good understanding of what this is. So, I'm going to start with you helping us understand the basics. What is the idea behind this particular section of the law?
All right. The idea behind the prevention of offences and security for good behaviour is to let the public know the role they can play in prevention of offences alongside the police officers, the magistrates or judicial officers, as the case may be, or public officers. Okay, like I usually say, the Acjl is like a criminal procedure or criminal law made easy. You know, way back then when we were in school, you have English made easy, maths made easy, that made easy. The Acjl is criminal law or criminal procedure made easy. So it's easy for the lay person out there to understand and also be able to comprehend and be able to do something to aid in the prevention of offences. Now, I also want to add that I won't be talking like a legal professional or a practitioner or a professional, as the case may be. When we were in school, we had a lecturer who would, when you talk, she would go like, "You're not talking loyally." Okay. so she actually expects that you employ some registers of the profession. So this evening, because of my audience, I won't be talking loyally.
Yeah, good. That's what we want.
Yeah, I would say it's the way the average person on the street will be able to understand me. Okay, so let's hit it. Okay, Section 50 to 56. That's our purview this evening. Okay, Section 51 says a police officer may intervene for the purpose of preventing and shall, to the best of his ability, prevent the commission of an offence. Of course, that's talking about the police officer. They already know their duties. But right now, we ought to know the role we should play. And when I mean we, I'm not talking as myself as a magistrate. I'm talking about the lay person on the street. What role are you going to play to aid in the prevention of offences? Okay, we'll start with that. That's the rule. Okay, if you move down, okay, you will say you have a police officer receiving information of a design to commit any offense shall communicate same information to the police officer to whom he is subordinate. First thing to check out here is that information has to come from someone.
Okay.
The police officer is not there everywhere.
Someone has to report the case.
Yes, someone has to report the case.
Okay.
So that's the role the average person on the street, okay, should play. Okay, you don't expect a police officer to sniff, his fingers to know that an offense is being committed somewhere.
Yeah.
The role of the public is to see an offense being committed or likely to be committed and now report to the police.
Okay.
That's section 50. Okay.
Now, but before we move on, basically, just to make this easier, is the fact that we are all looking at ways to prevent crimes from happening, and also it's going to be a partnership between the law enforcement agencies and the public. So it's not just waiting for the police to come do something. Once you see a crime being committed
or likely to be committed, yes, that is the essence of this provision. Okay, you don't wait until the crime or the offense is already committed.
When you suspect something,
yes, once you suspect, because basically down the line you will see suspect, which means you are suspecting that this person is likely to commit this offense. You don't just sit there laboring under a misguided opinion that the police officer or law enforcement agencies should know. Once you get a wind of it, go and report to the police. Go and give that information. Okay.
Now, whatever happens after that is none of your business.
Yeah.
As long as you've reported the case.
Yes.
And sometimes maybe you suspect a case, or for instance, you see a group of persons who are always walking around your vicinity, and you do not know who they are. Can you confront them, or is it advisable you go on report to the police first?
First of all, as long as the person is not yet committing any offense, you don't confront the person.
Okay, let's go that way.
You could just call, just like you do in a more civilized clime. Yeah. Someone sees an unfriendly face and an unknown face in a jurisdiction or in a particular street. The person just quickly puts a call across to 911. Yeah. Say, there is someone here. I remember visiting an aunt in the UK. She was like, please, before you go, let me know. Okay, someone sees you around here, will immediately call a 911. Yeah, that's the way it operates over there. Yeah. So Acjl is trying to get that being done here too. A situation where you see someone, someone you are not used to around your vicinity, walking somehow, dressed in a certain form, perhaps with a shield, on the face, it
looks suspicious.
Yes, you quickly put a call. I don't know what this person is doing around here. Please, can you kindly come around here and find out what this person wants? Okay. Or in a more daring situation, you can actually walk up to the person and say, please, may I know who you are? But because of the kind of society we live in, it's safer for you to just put a call across to the police. Yes.
All right. Now let's go over to section 51 of this law. So what does it say? What is the idea behind it?
The idea is that the police officer who received once he receives the information, will quickly hand over the information to the officer whose duty it is actually to prevent the crime. Okay, usually it is someone who he is subordinate to, as in someone who he is answerable to. You say, oh God, look at what is going on, look at the information I received, and the person should be able to act. That is section 51. Okay, then section 52, if we will run.
Yeah, let's go on.
Okay, it says, notwithstanding the provisions of this section of this law, any other law relating to arrest, a police officer, upon reasonable suspicion, that's the key word, upon reasonable suspicion of a design to commit an offense, may arrest without orders from a magistrate and without warrants the suspect where it appears to the officer that commission of the offense cannot otherwise be prevented. I would throw a light on that. A police officer sees someone who is likely to commit an offense. He doesn't just wait until he gets a warrant from the magistrate or gets orders from a magistrate.
Last week we treated on the arrest warrant.
Yes.
So this is the point where a police officer does not need a warrant of arrest to effect an arrest.
Yes, where he reasonably suspects. That's the key word.
Reasonably, we have to mark that word reasonably. Yes. Okay.
Reasonably, it's not just you see what is happening here. Down here you see police officers just arresting people like that. perhaps for one thing.
Based on how maybe they dress, they have dreadlocks or something like that.
Yeah.
They tag them criminals.
Whatever sparked up the NSAS protest and all that. No, this is reasonable suspicion. Your suspect, maybe someone is hovering over a building, peeping into the windows and all that, or someone is trying to pull up public property. You see the street lights and all that, or arrows marking directions and all that. Someone is just hovering around trying. You just walk up to the person and arrest. You don't need a warrant to do that.
Okay,
that's what section 52 is trying to say. If arresting the person would quickly avert that offense, you go ahead to arrest. Okay. Now
let's go over to 53 and the subsection 1s and the rest of them.
Okay. Section 53 says a magistrate or a judge or any public officer here now, not just a public officer, not just a police officer. Okay. A public officer has also been included. That's the idea behind the section 53(1). It says, or any other public officer. So if you work for the government or you hold a public office,
a civil servant?
Yes.
Okay.
This also applies. You don't wait and say, I'm not a police officer, I'm not a magistrate. No, the law also includes a public officer, charged with the responsibility of maintaining order, may intervene for the purpose of preventing and shall, to the best of his ability, prevent the commission of an offense for which he is authorized to arrest without a warrant, or any damage to any public property, movable or immovable. Like I said, the idea here, of course, we all know that a judge can actually arrest. Okay, a magistrate can, but the whole idea here is to add that a public officer, as in someone who holds a public office, can also do that.
When we say a judge, when we say a judge can arrest, basically what plays in my mind is a judge coming out to see the criminal and puts a handcuff on the person, and that's what comes into mind. But is this what it means?
No, that would take us to this section following it. Section 2,
okay,
or let's say subsection 2 says a person is bound to assist a judge or a magistrate or a police officer or any other public officer reasonably demanding his aid. Okay. So
before he can go with the help of a police officer.
Yes. Okay. Yeah. Even if he doesn't see a police officer, he says a person, any person. You're seeing a police officer, you're seeing a judge or a magistrate or a public officer beckoning on you. Look at this person is trying to commit an offense. Let's arrest him. Arrest doesn't just mean using handcuff. No, you can arrest by just saying you are under arrest. Yeah.
Okay.
You can arrest. Yes, you can arrest by just calling on people. I am so and so person. Flash your ID. Get this man arrested. He's trying to commit an offense. That's enough to arrest anyone. Okay. You must not use a handcuff.
Okay. Now, let me quickly refer back to section 50, where it talks about the power to arrest, where we talked about citizens calling the police when they suspect an issue like this, to calling the police. Now, can citizens also call on maybe a magistrate, a judge living within an area to report an issue like this, since he kind of has the power to make an arrest?
Oh yes, the law provides that a private person can arrest on your own.
Citizens arrest?
Yes, you can actually arrest someone who is committing an offense in front of you. You won't wait until you get to a judge or a magistrate. Okay, it's not enough to just lay a complaint. If you find someone, of course it happens now. Way back in Aba, once someone is committing an offense, you see the whole people, everybody will just gather and just hold the person and then hand the person over to the police. If we keep waiting for law enforcement agencies to arrest offenders, then we're not going to clear our society of very, very bad people or offenders actually.
Now let me just quickly state this, just for emphasis sake. Citizens arrest means you can hold the person when the person is committing a crime and hand the person over to the police, not jungle justice. Not saying that you should go about beating the person or burning the person. It states that you just hand the person over to the police. That is where your job is just to hold the person, capture the person, then hand the person over to the police. Okay. Now, because of time, let's move over to other sections of this law. We just looked at the subsection 2 of 53. Let's go to 54.
Yes. It says where a magistrate is informed on oath that a suspect is likely to commit a breach of peace or disturb the public tranquility or do any wrongful act that may probably occasion a breach of the peace or disturb the public tranquility, the magistrate may, in the manner provided in this part, require the suspect to show cause why he should not be ordered to enter into a recognizance with or without sureties. Now, let me say this. Okay, It says where a magistrate is informed on oath. That means you are talking about deposing to an affidavit.
Okay.
Okay, you don't just go to a magistrate and say this. This person is trying to commit an offense. The law requires that it has to be what?
Under oath. Okay.
Yes. And that's merely deposing to an affidavit stating that someone is trying to disturb the peace. Of course, these are the days of outrageous criminalities. People just wake up and just, begin to just disturb public peace. Threaten people for just no cause. Give quick notices, as we are hearing, okay? Leave this place and all that and all that. Someone is trying to do that, or is engaging people to go and disturb public peace. You depose to an affidavit. Okay, and then it is filed before the court registry and then brought before a magistrate. The magistrate invites the person by way of an order. That's where you have that arrest, okay, or rather warrant of arrest,
okay,
to get the person to come to court and show cause. Tell the court, explain to the court why you won't be arrested. Explain to the court why you won't enter into a bond. That's what is meant by recognizance. Okay, it's like a bond, in which a person promises either to do something or not to do something, or to come to court, or it's like a form that you get to fill. And then the law also says that the magistrate will now order the person to keep the peace for such a period not exceeding 1 year. Okay, so that you don't just keep someone in perpetual bondage and all that, to maintain peace, but at least within 1 year, if the person is able to maintain peace, then the person can go. All right. Yeah. So we're talking about security that's where security for good behavior. Well, we just talked about prevention of offenses.
Yes.
The second part is the security for good behavior. I had someone who wanted me to make an order, okay, detaining a particular person, okay, defendant in a matter. I asked her, has the person been granted police bail? She said, why do you want me to detain the person? She was like, the likelihood of committing that offense. I said, no. Once you come to court, let the court know that this person is likely to commit an offense. Then the court will bind the person to be of good behavior. It's safer that way than keeping the person in prison custody.
Okay, I'm sorry. This part seems new to a lot of, but I'm sure a lot of persons. You can make someone be of good behavior by doing this.
Oh yes.
Okay.
Just signing that recognizance keeps the person at bay. In fact, the person will be praying that nothing goes wrong in that environment. So, because you'll be held accountable. All right. So if someone is, let's say, it's like has been disturbing for a while, you do this, take the person go under oath, and this person is called by the judge and put under this recognizance. Yes. Means that it forces the person to be of good behavior. Oh, yes. And if anything happens in the environment, the first suspect has to be this person. Yes. Okay. That's simply what it means. Okay. If anything goes wrong in that family or from where the person is complaining from, the environment or a family or a setup or an organization, the first person to hold accountable is the person who has entered into that recognizance. So what he does is now to go to whoever is finding the embers of trouble. Please, I don't want trouble. I see you. I have signed a form in court. If anything goes wrong, I'll be here, and everybody will keep the peace. That is the essence of this section. Now. On this program, time is always running very fast because we've got about 5 more minutes to round off, and we have about 2 more sections to look at it. But let's look at 55. Okay. Where a magistrate is informed on oath that a suspect is taking precautions to conceal his presence within the local limits of the magistrate jurisdiction, and the B says there is a reason to believe that the suspect is taking the precautions with a view to committing an offense. The magistrate may, in the manner provided in this part, require the suspect to show cause why he should not be ordered to enter, which I think you already looked into this aspect also. Now, that will take us to 56. So, all right. Okay, let me just explain something. Okay. 54 and 55 are almost the same thing. The only difference is that 54 talks about breach of peace and disturbing of the public peace, while 55 talks about concealing your presence. Let's say the person came from another jurisdiction into the state, and the person is a wanted person and is really taking precautions to commit an offense in a particular. You know how cultists behave. Yeah. Okay, from one campus to the other, they come in, and you will reasonably suspect this person came in here to perpetrate a crime. Okay, So what do? You go to court the same way. Deposit an affidavit, okay, especially those in the universities, okay. You deposit and say this person has come into our jurisdiction, okay, and is trying to foment trouble. Then the court will invite the person via the warrant of arrest to appear before him or her and show cause. Explain to the court why you shouldn't enter into a bond, okay, to be of good behavior. All right.
I'm hoping.
And specifically too, this particular section makes provision for shorties. The first one doesn't. You don't need shorties. But this second one needs you. You must come with shorties that would stand for your good behavior, and also for the order will last for 1 year, or as the magistrate deems fit. Just exactly the same thing with section 54.
All right. In just 2 minutes, let's go through 56 so we can round it because we're out of time. Now, what is the idea behind 56? What does it mean?
Well, there are so many things enumerated here. Okay, what you should look out for before you go to court. Okay. All right. Just someone who is a terrorist, an armed robber, housebreaker, someone who receives stolen. You know this person is of a dubious character. Okay. What do? You say it's required. You still deposit an affidavit also on oath. The whole idea is that it is on oath. You don't just come to court like that. You just go to the magistrate, deposit an affidavit saying that this person is a terrorist, an armed robber, and all that. And the same way, the magistrate will order for the person's arrest, and the person is brought to court, and then he will enter into that bond for good behavior. Okay. Right. Yes. Now
we are out of time. This is the last minute I have. But before we go, let me. One more question is: where this is placed, recognizance is placed on a person, and the person leaves the vicinity. Does that recognizance stop?
No, it doesn't.
So wherever you go to, it's still going to be with you.
Oh yes, it doesn't. In fact, if the recognizance is such that you must appear before the court at any certain date, and you fail to appear, of course a bench warrant will be issued against the person to secure his presence to court.
And that entails arresting the person through any means possible.
Oh yes, and most likely he may not be granted bail.
Wow. Well, we've just been schooled this afternoon on this, but I've really enjoyed every minute of this. I wish we had more time to look at this, but I want to say thank you very much for coming.
Oh, you're welcome.
And if you joined in late, we've been talking about the prevention of offences and security for good behaviour under sections 50 to 56 of the Acjl 2017. Now, this is the first part of it, and I have been speaking with His Worship Chinwe Bob Ogu. Thank you very much for coming to our studios.
You're welcome.
All right, don't forget this program comes your way every Tuesday from 3:30 p.m. It is brought to you by the Abia State Administration of Criminal Justice Monitoring Committee and Prisoners Rehabilitation and Welfare Action PRAWA, with the support of the Open Society Initiative for West Africa (OSIWA) and the Abia State Justice Reform Team. My name remains Ifani. Our stay tuned to more coming up right here till next week Tuesday, when we'll come up on the episode of Wheel of Justice. Please continue to obey the law. Bye for now.